unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a constituent assembly in due course, which will go into matters I have referred. When it has come to a decision, will either abrogate 3068 or direct that it shall apply with such modification exceptions or make recommend. That, sir, is briefly description and effect of this article. I hope the House will carry. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the Constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
Sayajirao.
Sayajirao. I was shocked to read because Sayajirao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordship knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharishi Aurobindo, who stayed in Baroda for many years and some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s. So the man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford-Cambridge lines. So, and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that. Now, he therefore didn't want to. Now, just see, my learned friend wants me to read, at page 1177 perhaps, or 1178. Now it is not case. Which page? 1177, last para.
In fact, 1178, see that one para which says, now you will recall.
Yes. That in some of the clauses of this article, we have provided concurrence of government of state feel that in view of commitments already entered into between state and center, they cannot be regarded as final authorities for giving this concurrence, though they are prepared to give it in the interim period. But if they do give this concurrence, this clause provides that concurrence should be placed before Constituent Assembly when it meets, because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was still the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, that may perhaps
what he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case, really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
We see that on C and D at page 1177, clauses C and D refer. Your lordship, see, clauses C and D refer to provisions of Constitution. My lords have it?
Yes.
Clauses C and D refer to the provisions of the Constitution other than matters listed in List 1 and 3. These various provisions have been divided in certain categories. First, according to this draft, is Article 1 of the Constitution will automatically apply. As you know, it describes territory of India and includes amongst territories all states mentioned in Part 3. J&K is one of the states mentioned in Part 3. With regard to other provisions of the Constitution, these will apply to Jammu and Kashmir state with such exceptions and modification as may be decided on when President issues order to that effect. That order can be issued in regard to subjects mentioned in instrument of accession only after consultation of government of state. In other matters, concurrence of that government has to be taken. What your lordship read was in Part 2, because the government was an interim government. So whether that government was rightly giving rightly giving advice or concurring, so they said let people decide to that limited extent. Now next para. Now it is not the case, nor it is the intention of members of Kashmir government whom I took opportunity of consulting before this draft was finalized. It is not their intention that other provisions of Constitution are not to apply. Their particular point of view is that these provisions should apply only in cases where they can suitably apply, but only subjects with modifications and exceptions as particular conditions of J&K state may require. I wish to say no more about particular point. So that is how he looked at it. That is how he defined. There is no other interpretation possible. This is the author and one of the most respected, eminent citizens of this country. On 5th of August, President issues a proclamation. Then it is sent to Rajya Sabha. Rajya Sabha sends a recommendation without on the same day. Then Rajya Sabha approves reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. These Constituent Assembly debate took place over several years. These are the men and women who are most brilliant that have ever been born in this country. We owe a permanent gratitude to them. And if we were to interpret Constitution as today's governments tell us, we'll be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of brought in various provisions to recognize this. It's not the article is not just a letter. It's the feelings of people of Jammu and Kashmir.
What next, Mr.
Yes.
Davina?
Now, Lord, kindly come to, in this context, the two judgments which I respectfully submit are squarely supports the view that I have. Lord, kindly turn to PDF volume 1, isn't it? At page 8. Premnath called. It's 1950.
Volume 1 of the case.
On October 25, 1947.
Volume 7.
Which page?
Srikanday, volume 1, page 7. Case law compilation.
Para 10. Your Lordships may turn to para 10. Lordships have got it? On October 25, 1947, Maharaja signed an instrument of accession with India, which had then become an independent dominion. By first clause of instrument, the Maharaja declared that he had acceded to dominion of India with intent that Governor General of India, Dominion, Legislation and Federal Court, and any other dominion authority established for purpose of dominion shall, by virtue of instrument of accession, subject always to the terms thereof and for the purposes only of dominion, exercise in relation to state of Jammu and Kashmir such functions as may be vested in them by or under Government of India Act and so on. We may usefully refer to some of the other clauses of instrument. Then Lordships may omit all that. And please kindly, thus, last sentence of that para. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India. Now kindly turn to my lord. Lord, please turn to paragraph. There is one more argument. Page 287. I haven't written. PDF page 15. Para 26. No, where is para? Page 16. Para 26. There is one more. No, just before that. Lord, just before the paragraph 26. Please see last sentence of para 25. We must of accession. Oh, para 26 last sentence. I'm sorry. Why are you confused? I asked you to write this down and be carefully yesterday. Last part of para 26. We must therefore reject the argument that the execution of instrument of accession affected in any manner the legislative, executive and judicial powers in regard to government of state of which then vested in ruler of the state. So for all purposes, your Lordship's court recognized that not he was the state who wielded all the powers. And his instrument of accession didn't take away those powers. Although he became part of India. Now see, my lord, next paragraph. There is one more argument which has been heard before us on the question of Maharaja Hari Singh's powers. It said that Maharaja issued proclamation on March 5, 1948, replacing emergency administration by a popular interim government headed by Sheikh Abdullah, constituting council of ministers who were to function as cabinet and act on principle of joint responsibility. He virtually introduced a popular democratic government in state, surrendered his sovereign rights and became constitutional monarch. There is no substance in this argument. The proclamation merely shows under pressure of public opinion and as a result of difficult and delicate problem raised by tribal raid, Maharaja very wisely chose to entrust actual administration government to charge of popular cabinet. Then Lordships may omit all that